Hello, welcome again to our Lecture 6 for Company Law Lectures by Simplifying LLB Law Series. My name is Ayub Okayo, and today I'll be teaching you about company meetings and resolutions that come from those meetings. This topic will therefore cover the manner in which the company meetings are held, who can call for those company meetings, requirements for constituting a company meeting, and also we shall cover resolutions that come from those meetings. So welcome. Let us now explore this topic together. Now, for a company to make certain actions, the members may have a say to what the company will do, or perhaps the directors of that particular company. The members of a company will give directors some specific powers and then will reserve those powers for the company meetings. And they will, of course, do this by a way of inserting such a kind of requisite for certain actions to be vetted or be authorized through a meeting within the articles of that particular company. So, for these meetings to happen, there's normally several procedures that need to be followed before a meeting can take place. However, once the meeting has already been constituted, members will come up with a resolution to several of the issues that have been tabled before that a particular meeting. And a meeting, of course, can be either an ordinary meeting or a special meeting that comes up with a special resolution or an ordinary resolution. So, with regards to the resolution under Part 13 of the Companies Act, the resolution of members of a private company may be passed either as a written resolution or at a meeting of members. Now, with regards to the public companies, a resolution of members of a public company may only pass the resolution within the meeting. However, with the private companies, a written resolution can also be deemed as a good resolution. And of course, this is because of the way the private companies are run. Sometimes you may find that the owners of the company are also the directors of that particular company. So a written resolution may still suffice. So resolutions are either ordinary resolutions, which means that a resolution has been passed by the simple majority. So if it's 50 plus 1 vote, then we can say that that's an ordinary resolution. And if it passes, then it has certain meanings. And also, we have a resolution which may be deemed to be a special resolution, which members must pass as the majority or with the majority vote. And that majority vote will be on a percentage of 75% of the votes. And of course, for it to be ordinary resolution or a special resolution, the Articles of Association of a company normally lays down which elements cannot be passed by a mere ordinary resolution, but can be passed by special resolution and vice versa. So for you to know which kind of resolution can be passed in a particular meeting will depend on how the Articles of Association has described that kind of meeting. So if they say for you to remove a director, there must be at least a majority of um, the shareholding to vote on a percentage of 75% of two-thirds of the members who are present in that particular meeting. So if the removal of a director requires a special resolution, then that will be the only way, and that will be captured within the Articles of Association. Now, how do they vote? How do members vote for these resolutions? So once they have debated on a particular topic or issue and they want to vote, most of the time, as a general practice, they normally vote that each member has only one vote for each share that they hold within that particular company. And that is a company which has a share capital. But for those companies that does not have the share capital, like maybe companies guaranteed, like the share capital is not there, but it's only a company constituted or limited by guarantee, then each member will only have one vote. So if it's by shareholding, we'll have one vote for each share, which is paid up share or subscribed shares within that particular company. And if it's by limited by guarantee, for such companies that are limited by guarantee, then each member will only have one vote. Now, we have meetings under Part 13 of the Companies Act. And with this, we have two separate types of meetings. And the first one is the annual general meeting, which must be held at least once in a year. And that is under Section 275A of the Companies Act of Kenya 2015. Of course, in the event that a company has a single member, or maybe it is solely owned by only one person, then this requirement of holding annual general meeting at least once in a year will not be applicable if it's only a company held by one member. But if it has more than one member, even if it's a private company, the Companies Act under Section 275A requires that such company constitutes at least once in a year an annual general meeting. And of course, in this annual general meeting is where they're going to table the reports on the financial position of the company, and also reports on several dealings of the company, and many other issues will be discussed within that annual general meeting. And of course, sometimes that's the place where the members may have a say on the director's position, or also look at and assess what the directors are proposing that the company does. Um, so, who can convene a meeting in a company? So, the directors may convene a meeting, which is an annual general meeting. And of course, when they constitute this kind of meeting, it's required by the act that they do constitute such a meeting within a period of 1 year. And in the event that they do not comply by constituting this meeting, a company, registrar of companies, may flag this one, and it will be a violation of the Companies Act. However, not only directors can constitute a meeting, but also members can require that directors convene a general meeting, and there are several requirements that must be fulfilled for a meeting that is being called by the members of a company, in or members requiring directors to convene a general meeting. The threshold for members who can request for the directors to convene an annual general meeting is about 10%. So at least 10% of members of paid up capital will request for the directors to constitute for the meeting, and that will be effected. And where the directors refuse to convene for a meeting, then um, the if the directors refuse to convene a general meeting and it has been requested for by the shareholders, then um, the members themselves can go ahead and constitute that meeting, but at the expense of the particular company. It's also worth mentioning that for a private company, it's the 5% of the um, share shareholding, or the shareholders, at least 5% of that, can request for an annual general meeting to be constituted by the directors in the event that 12 months have passed since the last general meeting. Now, directors, once they have been requested to convene this meeting, they are required to, within 21 days, to set up a date, to set up a date, the venue, and the agenda for this particular meeting. And of course, in the event that 28 days have passed without convening this meeting, it will be in violation of Article 275A. Now, we also have the private company requiring that at least 21 days notice be convened, especially if the meeting which is being called for by the directors, the 21 days notice be given to the members. So within that 21 days requirement, and of course, it will highlight several aspects of that meeting and the nature of that meeting and the agenda to be discussed within that meeting. Whereas the public company requires that the members are given 21 days notice. That is in case of the annual general meeting, if it's a general meeting. But if it's not a general meeting, it can be a notice of only 14 days for any other meetings that I already spoken this, that there are several meetings that a company may constitute. It can be in addition to annual general meeting, which is compulsory by law. A company may hold several other meetings. It's not precluded from holding several other meetings, but at least they must hold at least one meeting a year, which covers it's the annual general meeting where all members are invited to that particular meeting. Now, a general meeting may be convened by a shorter notice if and only if at least 90% of the majority shareholders have agreed or have requested for it to be so. So we can slice the timeline, which is the 21 days, into a very short notice kind of a meeting. If the members, at least 90% of the members, have requested or are okay with this particular meeting being constituted on a short notice, other than the 21-day period as required within by the law, the Companies Act of Kenya 2015. Now, when circulating this notice for that particular meeting, the directors are mandated to mention several things or specify some particulars. Some of those will be the date when this meeting is going to be held, the venue where this meeting is going to be held. If the venue is online or physical, they have also to indicate. If it's online, they have to indicate how members can participate, how are they going to join. It must also indicate the agenda for the meeting. What are we going to discuss in that meeting? It must indicate the time when that particular meeting is going to be constituted. So this must be provided to the members at least several days before the meeting happens. If it's a normal meeting with not necessarily an urgent short-term notice kind of a meeting, then the law requires that at least 21 days notice be given to the members. And that notice will bear those things: time, date, place, agenda, etc. So it must be well specified within the notice. So every resolution that is done by these members in that particular meeting, it must be minuted. So every agenda and every discussion within that general meeting or special meeting, whichever meeting that they have, all that must be minuted and be kept for they must be kept within the records of that particular company. And in case there's a dispute in future, at times they normally go back to look at how the proceedings happened within that general meeting and then what was discussed. So the law requires that at least 10 years within the the 10 years after the resolution has passed, that kind of record be kept within the company records. Now, this brings us to an end of our topic on the meetings and resolution that come from those meetings. I hope you have understood how the meetings are constituted and also how resolutions are arrived at, especially when it is a special resolution or an ordinary resolution. So, thank you very much and see you in our next lecture, which is going to cover the shares of a company. There, we're going to divide the type of shares and also look at classes of shares and several aspects of this particular topic. So thank you very much and see you in our next lecture topic.